Good afternoon. Thank you so much for being with us. Thank you so much for being with us today. I'm Janice Kaminer-Resnick, and I welcome you on behalf of our leadership team, which aside from me is former Congressman Mel Levine and former Los Angeles County Supervisor Zev Yaroslavsky. We thank tonight's special guest, former acting U.S. Attorney General Neal Katyal, and our moderator, Madeleine Brand, for agreeing to be with us tonight to discuss a topic that produces lots of anxiety, Trump, the courts, and their possible impact on the election, but we will all be smarter after tonight's program, if not less anxious. Next week, on May 29th, we will present journalist, author, and foreign affairs analyst Jacob Heilbronn, who will discuss America Last, the right's century-long romance with foreign dictators. Whoops, sorry about that. For the past decade, Jacob Heilbronn has been the editor of the National Interest of Foreign Policy magazine, which was founded in 1985 by Irving Kristol. He is a non-resident fellow at the Atlantic Council and editor-in-large of the Jerusalem Strategic Tribune. Previously, he was a senior editor at The New Republic and an editorial writer for the Los Angeles Times. He writes on foreign and domestic issues for lots of different publications. It should be a great program. Hope you'll join us. A few little housekeeping notes. All of our past 210 programs are recorded and appear on our JewsUnitedForDemocracy.org website and on our YouTube channel, which is called America at a Crossroads. We also provide our programs via a podcast starting the morning after each program. So if you loved a program, you can lead people to the link, which is in every single email you get from us, the link to all of these things, past events or to the podcast, if you want to watch it or just listen to it. A reminder, if you aren't getting the link, all you have to do, it comes in an email from Zoom, not from me, but all you have to do is re-register for the program within an hour before it starts, and you will get a really easy to use join webinar email from Zoom. So I suggest that you do that. Of course, you know you can email me and I'll do my best to get you a link. Now to introduce tonight's guests, please welcome my colleague and friend, a vital member of our America at a Crossroads leadership team, and also Jews United for Democracy leadership team, former Congressman Mel Levine. Mel, it's all yours.
Thanks very much, Janice. It's a real pleasure to be able to introduce Neal Katyal. Those of us who watch MSNBC regularly, I think it's fair to say, feel like we know him reasonably well. And I also think it's fair to say that we are grateful for his routinely thoughtful, clear, and insightful analyses of some of the most important and significant legal matters facing our country. I also have wondered whether Neal has 36 hours in each day. In addition to his MSNBC appearances, he's a partner in a highly regarded law firm, as well as a professor of national security law at Georgetown University. He was the acting Solicitor General and Principal Deputy Solicitor General in the Obama administration. I believe he has argued more Supreme Court cases than any other person, even at the young age of 54. These cases include some of the most important constitutional matters facing our country, including cases related to voting rights, limits of presidential power, and separation of powers. He is also the author of the New York Times best-selling book entitled Impeach, the Case Against Donald Trump. He will be interviewed by Madeleine Brand. Madeleine is the host of the award-winning daily news and culture show Press Play, which airs on NPR's Los Angeles affiliate KCRW. Madeleine has hosted and reported for NPR and for NPR's stations for more than 30 years. She has a master's degree from Columbia Journalism School, where she also taught documentary radio. And I turn it over to Madeleine.
Thank you very much, Mel, and thank you for Janice for those kind introductions and inviting me back. And Neal, it's great to see you again. Thanks for coming back.
Great to see you.
Well, we have a lot to talk about. Lots of stuff going on in the legal world, as there seems to always be with Donald Trump. So let's first talk about the trial that the two sides just rested in Manhattan. Closing arguments are expected next week, along with the case going to the jury. First of all, are you surprised that there actually was a trial? Because it seems like this might be the only one of the four before that goes to trial before the election.
Well, first of all, it's a real privilege to be with you, Madeleine, and with everyone here. I've done this talk now, I think 3 or 4 times, and it's just really warm, and it means a lot to me to have you guys invite me back. So thank you for that. And yes, I do think it's like, I mean, our legal system is designed, of course, to give everyone due process and rights. And it's kind of written for a litigant that generally behaves in good faith, and for judges that behave in good faith, and prosecutors and other actors that behave in good faith. And one of the things that has happened with Trump is that you've had kind of the weaknesses of the legal system laid bare for everyone to see. And you see him filing frivolous motion after frivolous motion here, there, wherever, to try and delay the cases. And we'll go through them, I'm sure, in the course of this hour, one by one. But with respect to the so-called hush money trial in New York, that's the one, Madeleine, you're right, in which he wasn't successful in delaying it. It also is in some ways the least important. I think it's still very important, but it's not like trying to launch a coup to overthrow the government, or like taking highly sensitive classified information, something that, you know, anyone else who did, they'd be put in jail immediately. So it's weaker than those in the sense of the gravity of it. It's still important, but that's the one that has gone to trial. And of course, you know, as I and others said, Trump said, "Oh, I'm innocent, I'm going to testify, blah, blah, blah." And we learned yesterday, of course, he doesn't testify. He's a chicken when it comes down to it. And his lawyers probably would have walked if he tried to testify, because he has a very inconvenient relationship with the truth. So, so yes, we've had the case rest. That defense called a whopping 2 witnesses. One was like a paralegal and who basically just authenticated some stuff, and the other was Robert Costello, who had a bunch of dealings with Michael Cohen, and tried to paint out Cohen to be essentially a liar, saying, you know, Cohen had told Costello that Trump had nothing to do with this. And that's the essence of the defense, which is Michael Cohen is a liar, Donald Trump is telling the truth. I think everyone outside of a court of law knows that argument to be really, really tough. You've got not just Cohen, but all sorts of other witnesses that corroborate it. You've got documentary evidence showing this. And of course, you've got the amount of money, which happens to be magically, you know, a grossed up amount that Michael Cohen was owed by Donald Trump, and Donald Trump paid it. And you've got all sorts of testimony that Trump, you know, watched every penny and would never have permitted one of his attorneys to just cut a check for all of that money without running it by him. So you've got kind of just common sense and the like, but what Trump is hoping for here is to play on the asymmetry of our system. I mean, when our founders brought the jury system from Britain, they really did have this idea that it's better to let 10 guilty people go free than one innocent person be convicted. And it's reflected most powerfully in the rules about jury unanimity, which New York operates under. And so the prosecution has to run the table. They have to win all 12 jurors. If one juror says, "Hey, I don't think Trump did it," can't convict him. It'd be what's called a hung jury, and he could be retried, and he very well may be retried.
What do you think
that's
the chances are of a hung jury?
Oh, I can't speculate on that. I mean, that's really a focus of the individual 12, and anyone who tried to handicap that, I mean, maybe they know stuff I don't, but like I can tell you, when I was doing the George Floyd murder, I was special prosecutor in that. And, you know, we felt the case against Derek Chauvin was as strong a case as could be imagined. And we, you know, the evidence presentation went really well. We thought the defense didn't go well. But if you ask me, you know, even the morning of the verdict, what's going to happen, I couldn't handicap it at all, because you are for better or worse in the American jury system, relying on, one person can mess it up. And it's, sometimes hard to predict how one person is gonna behave. So I don't want to say, I will say, based on what I saw of the trial, and I couldn't see the trial, I was just reading the transcripts, and that's something I hope we'll talk about. The unbelievable fact that we have this major trial, we have these Supreme Court proceedings going on in Washington, and you and I can't see it. It's just,
Right.
to me, the most undemocratic thing imaginable. But leaving that aside for a second, based on what I've seen in the transcripts, I do feel like if it is a hung jury, that the prosecutors will move to retry him. That they won't just fold their tent and say, oh, okay, we're going to go home. And, I think that's particularly true because one of the two defense witnesses that was called, this guy, Mr. Costello, first of all, the prosecution wasn't given much advance warning that they were going to call him. And then Costello behaved in really very problematic ways on the stand, leading Judge Merchan to really give him a dressing down.
Yeah.
And I don't think it's like a mistrial that the prosecution can move for, but I do think that if Trump does manage to pull a juror or two to say he's not guilty, I think that will be part of the basis for a retrial, which is the defense's tactics here. So we'll see, and we'll probably know by the end of next week, by Friday, whether Trump is convicted in this case.
Are you saying that the defense would actually want to have a retrial?
Oh, no, the defense doesn't want to.
No.
I'm saying the defense, in a way, by doing what Costello did, handed the prosecutors a massive backup insurance plan. I'm sure that they didn't intend it to happen that way, the defense, but the way it came out was to basically make the case for, if there is a hung jury, for Trump to be retried. So no, of course, the defense hopes for an outright acquittal, which I think is, I will handicap that. I think that's impossible, that 12 jurors are going to say he didn't do it. My guess is that the jurors will say he did it. He authorized the payments. I think the evidence on that is overwhelming. The question is whether or not they can elevate it to a felony. And for it to be elevated to a felony, the prosecutors have to show that he did this in furtherance of some other crime, most likely here campaign finance violations. And I said at the beginning that this wasn't as serious as the Mar-a-Lago stolen documents case or the 2 January 6th prosecutions against Donald Trump, which is right, but it is serious. Our whole campaign finance system is written to ensure that, unfortunately, because of Citizens United and stuff like that, people can give lots of money, corporations can give money, but it does insist on transparency in the process. So yes, you have a right to give money and to receive money, but the American public have a right to know, if you're running for office, where your money's coming from. And what Trump did here is just, right after the Access Hollywood tape, that grotesque tape, this story was about to come out. And National Enquirer all of a sudden got, a certain amount of money to kill this story. And that's where I think the transparency point of the campaign finance laws are so important. Trump didn't want to cut a check himself. His defense attorneys have said, oh, Donald Trump could have written a check himself to pay off this money. But if he did that, you and I would have known about it. And in a very close election, as 2016 was, this could have been the most important, secret campaign contribution in the history of the United States. It very well may have swung the election. And Trump knew that, which is, of course, why, the prosecution saying he authorized all this. It wasn't done, as Trump says, to protect his wife, Melania. Indeed, Michael Cohen testified at one point that Trump just said, let me get through the election. I don't care about Melania. That's a he said dispute. The jury can assess that. But when you've got a witness who's pretty contrite on the stand saying this is what happened, and you don't have Donald Trump on the other side saying the opposite, the jury very well may be left with a certain impression. There will be a cautionary jury instruction because of the Fifth Amendment, the jury's going to be told you can't infer guilt from the fact that Donald Trump didn't testify. And that's absolutely right in the American legal system. And that's true for criminal cases. I do think that members of the public, though, have a different standard. And when you're running for office, you have a different standard. And I think we are all entitled to infer something because Donald Trump did not testify.
Speaking of the jury instructions, is it unusual that they are going to be spending several days arguing over exactly what Judge Merchan can tell the jury? And what is it that is so crucial here in terms of his instructions?
Jury instructions are kind of like the ball game for in a lot of these criminal trials, because that sets out the legal standard for a conviction. And so explaining what beyond a reasonable doubt is, that it's not 51% that you think the person's guilty, that the defendant's guilty. It's actually the highest standard in the law that the prosecutors are going to have to meet, which is, much, much higher than 51%, or explaining what we call the mens rea, the criminal intent that is necessary here. So that if Donald Trump was just oblivious to what Cohen was doing, that's generally not enough under the law, a negligence standard or something like that. He has to be more intentional and willful in his actions, that he's directing Cohen to do something. So yes, I think that here those jury instruction debates will take a while. I don't think it'll take several days. My guess is it'll all be resolved on Tuesday, and we'll have closing arguments after that. But it is significant because the legal standards will matter. They'll matter not just for the trial, but also for the inevitable appeal if Donald Trump loses. And I should say one important thing, some people think, and I get this from my viewers all the time, oh, if Trump is convicted, it means he's going to, in this hush money case, it means he's going to jail right away. And how is he going to run for president if that happens? And that's not the way the legal system works. First of all, he's got to be convicted of a felony probably to go to jail at all, be eligible for jail, which means that they have to prove that he acted with some sort of intent to have a campaign finance violation or to cover up some other issue of law, of criminal law. But then even if he's convicted of that felony, he's going to file, even if he's convicted of the felony, he may argue he shouldn't get jail time as a first-time offender. My guess is that probably won't succeed, and he'll probably at least get some sort of home confinement or something like that. But then the most important thing is in our legal system, and again, it bends over backwards to give criminal defendants rights. He's going to file what's called a motion for bail pending appeal, which means that he's going to say to the judge, look, I'm appealing my conviction, and I have good faith belief that this conviction is wrong. You instructed the jury the wrong way. The jury was biased, whatever his arguments are. He's going to say to the judge, let me out and be free pending my appeal. The only time you can jail me is after my appeal is all over, which would likely mean going first to the New York Intermediate Court, then to the New York Court of Appeals, the highest court, possibly then even to the United States Supreme Court. So it's some years away before Trump is likely to actually be imprisoned, even if he's convicted of a felony, and even if that felony includes, as the judge imposes sentence, jail time.
But of course, we've never been here before, so we don't know exactly how this will play out or how it should play out. And if the judge could, if let's say he gets reelected, could he then be sentenced somewhere within his term? If you say it's a couple of years, would it be 3 years from now? And then a sitting president is sent to jail.
Right. So you're absolutely right. This is the first prosecution of a former president. I think it's the first prosecution of a leading presidential candidate. I don't think Eugene Debs probably qualified as a leading presidential candidate. So in that sense, it's unprecedented. But we have been here before in the sense of just these routine motions for bail pending appeal and the like. So Trump is going to get all of those protections, which make it very unlikely, if he were to win the presidency in November, he probably wouldn't see jail anyway because of his ability to stretch stuff out, stretch all the appeals out. Now, let's just say that the appeals failed more quickly. He still would have a good argument, and I actually believe this argument, that the structure of the Constitution forbids one state from jailing the President of the United States. A federal prosecution is different because that acts on behalf of the whole United States. But to let one state undo the nation's work as a whole really flouts, to me, the most important opinion in all of constitutional law, which is a case called McCulloch versus Maryland in 1819, which is about the Bank of the United States. It's the big part of Hamilton and Cabinet Battle #1. But the basic principle is we don't let one state undo the nation's will. And the best way of understanding it, and I understand many viewers, tonight may be like, how can that be? That sounds crazy. But just imagine if it's 1862 and South Carolina tried to indict Abraham Lincoln. And we wouldn't want one state, or 1861, we wouldn't want one state to be able to interfere with the nation's will. And so that kind of principle is really etched into the Constitution. And that's why, people say, oh, the state cases, New York and Georgia, are the really important ones because Trump can't pardon himself or order the Justice Department to drop the prosecution in those cases. And that is true that Trump doesn't have power over the state system, but he probably does have the constitutional authority to act as president and not be interfered with while he's serving his term, and prevent a incarceration by some state.
In terms of how this is playing in the public sphere, you have the spectacle of all of his supporters in the courtroom. Maybe it's a varying cast of characters. One of them included Alan Dershowitz. And then you have this constant attack during his rallies on the court, on the judge. Of course, he has been fined for some of that, but it's a constant undermining of not only this particular case, but of the system in general, as persecuting him, part of the deep state, all of that. I'm wondering what you think the long-term effect of that will be, and not just on his ardent and fervent supporters, but on the nation as a whole.
I think it's such a good question. It's horrendous behavior for any individual, but particularly for someone who is claiming to be wants to be the chief executive of the United States. I mean, what makes our system so great is our institutions, whether it's the jury, whether it's the court system, and Trump constantly spits on them. And I just don't understand how you can have one can have a president who has such contempt for the things that actually make America great. I can tell you, if any other person said the kind of stuff he's been saying in New York about the judge and the prosecutors and the witnesses, they'd be in jail. That is not the way the system can work, because witness intimidations are a really serious thing. And in the biggest cases, like Derek Chauvin, you take real care to make sure the defendant, or the prosecution for that matter, not going out and trying to poison the jury pool. It's very, very important. And here you've got someone who just spits on these things. And so I do worry very much about the corrosive effect. I mean, if you're the attorney general in the next Trump administration and you're bringing hard prosecutions against, drug lords or murderers or, you name it, politicians, and you've got all this rhetoric about how the system can't be trusted and the like, that's going to be thrown right back at you as the attorney general or as prosecutors, line prosecutors. And that's a really frightening thing. I mean, I've spent 2 different tours at the Justice Department, and I can tell you how amazing it is and how apolitical it is. I had the privilege of running the Solicitor General's office, which is an elite group of 20 lawyers that argues before the Supreme Court for the federal government. And 18 of the lawyers are career lawyers. And One is the principal deputy, that's a political job, that was mine, and then the Solicitor General, which is a political job. And when I came in, and Elena Kagan was the Solicitor General, and we were waiting for her to get confirmed, I went around and looked at the office, and it turned out that of those 18 attorneys, and this was the Bush administration who hired them, the George W. Bush administration, you know, a majority of them, an overwhelming majority, were liberal. And yet, you even had accusations that the Bush Justice Department was politicized and stuff. Not in that office. I mean, my predecessors in that office took real care to have career hiring and just hire the best people. Didn't matter what their politics were. And certainly that's what I tried to do. And I think the way the current Solicitor General behaves. And so that's how the system works best, is when you have these brilliant career people who aren't in it to try and, score a cheap political point, but are just trying to do the nation's business and further the Constitution. And that's what I saw every day in my 2 tours.
Okay, let's move on to the case that is currently before the Supreme Court. And from what I've heard, they may issue a ruling as early as next week on this. I don't know. This is the presidential immunity case, and it revolves around the federal charges against him, 4 counts related to election interference. Supreme Court deciding whether or not he should be immune from prosecution because he was president at the time. And the lower courts just said, no, that's not a good argument. They dismissed it, Trump's claim, and yet the Supreme Court took it up. So before we get into the oral arguments, because I know you followed them orally, you couldn't see them visually. What does it say to you that the court took the case to begin with?
So first of all, I actually did see that one visually. I was in the courtroom in the front row.
You're one of the lucky few.
Yeah, and actually, I think it really mattered, and I'll talk about like what being in the room versus the audio or the written transcript, why it's different, and why I think a lot of the media coverage was so skewed. But they took the court case because, I mean, again, we're guessing here, but my strong hunch is because it's an unanswered question in constitutional law. Can a president, while president, be guilty of a felony, while acting as president, be guilty of a felony? And under what circumstances or does the president have some official immunity for his acts? So that's different than, for example, the hush money case, because that occurred in conduct in October of 2016 and before Donald Trump was president. Here, the allegations are, you call it election interference, but I think it's really dramatic, an accusation that the President Trump basically tried to launch a coup and give aid and comfort to those launching a coup. And Trump's argument is, well, I was acting as president, and so you can't prosecute me. And so the fact is, the court has never answered that question because no president has ever been in the zone of being anywhere near criminal activity until Donald Trump came along. And so they haven't been asked. Now they're asked, and so they wanted to decide it. I think that the argument itself, if you were listening to it and it went on for 3 hours, I think led a lot of people to think, oh, the Supreme Court thinks there's really something to Trump's argument, which is not how I saw it. So early in the argument, Trump's lawyer stood up, and it was very theatrical and not really Supreme Court-y. Didn't know which side of the courtroom to sit on, think things like that. But early on, Justice Sotomayor said, look, in the lower court, our DC Circuit, our nation's second highest court, you were asked if the president goes and sends out Navy SEAL Team 6 to go and assassinate his political rival in the midst of an election, is that something that he has official immunity for? And you said yes. Do you stand by the answer? And he basically said yes. And at that moment, Justice Barrett, who's sitting right near Justice Sotomayor, you could just see her eyes go up in like a gasp, because that's just a crazy argument. I mean, maybe it works like for the Russian Constitution, I don't know, but it's not the American Constitution. Nobody thinks it is. So, but yes, the court did entertain hypothetical after hypothetical. What if there were this president doing this or that and so on? And, to people that aren't as familiar with the Supreme Court, I could see why they thought, oh my God, the court thinks there's a lot here. It may be that I'm wrong, I mean, I certainly have been before, but it seemed to me like the court is doing what it does all the time, which is testing the logic of the positions of both sides. And when Michael Dreeben, who was the lawyer for Special Prosecutor Jack Smith, stood up, about halfway through the argument, and it was like an hour and 55 minutes in, Michael Dreeben explained, here's what the allegations are about Donald Trump, that he went as president to the Justice Department and pressured them into sending letters that everyone knew were a lie to the state legislatures about how the election had no integrity and how they had to take it on themselves to throw out the popular vote and to vote him into power. And Dreeben further explained that Trump's own appointees at the Justice Department refused to carry out that order and said they would resign. There isn't a way to think of that as an official act. Indeed, the founders of our Constitution give the president sweeping powers in Article 2, like the commander-in-chief power, or the power to take care that the laws be faithfully executed, sweeping powers of law enforcement. But the one place that the president has no power is over elections. And for the most obvious of reasons, the thing the founders feared the most was self-dealing by our nation's elected officials, that they would use their power to keep themselves in power. So the president has no power over elections whatsoever. And that's why I think the case turns out not to be that hard. I think that's why in the lower courts it was rejected, the immunity stuff. And I suspect that's what the Supreme Court will do. And I suspect they'll probably do it soon. Is that enough time to try Donald Trump? That's a hard question. The judge in the trial court, Judge Chutkan in Washington, D.C., said she wanted to give Trump about 81 days from the time the immunity decision was decided to start of trial. And so it's possible to have this trial 81 days and still happen before November, but it's hard. On the other hand, like, I can't think of something that voters need to know more than, like, did this guy foment a coup and do what he's accused of doing to the Justice Department? Because if so, it's not just criminal, it's also easily disqualifying for holding office. So one way or the other, I think the information has to come out to the American people. Now, I think Jack Smith does have a backup plan. If, let's say, the Supreme Court waits until the end of June to decide the case, and the 81-day timetable makes it too hard to have a full-blown jury trial, there will be hearings on what Trump did and whether it's an official act or not. And Smith could use those hearings to call witnesses and to present documentary evidence about what Trump did. And that's a way to, and Trump can cross-examine it, of course, through his attorneys, but that's a way to try and get that information to the American people. And that's really important because, and it's not something I knew until a few weeks ago, but Liz Cheney, who was the vice chair of the January 6th committee, wrote a New York Times op-ed in which she said, look, we, the January 6th committee, got a lot of evidence, but there was a lot we couldn't get. It was stymied in all sorts of ways, and we didn't have the strong subpoena power necessary to get it. But Jack Smith did, and he got all sorts of information the American public has never seen.
Wow.
So,
well, I'm so surprised by that because I thought we heard so much during impeachment. We had so much testimony. There was so much shocking evidence presented that for people who were paying attention, I mean, you could see exactly what happened, and they would already have an opinion. But you're saying that there would be more information that the voters would need right before the election.
Yeah, that's what Representative Cheney is saying, that yes, and I completely agree with you. The evidence about his guilt is overwhelming already, but you got to wonder what's the stuff they were so afraid that they were willing to go to court and block it from coming out. There must be more, and maybe it's clearer evidence or easier to understand, or what, who knows? But it certainly seems to me in a democracy, the American public should get to see it.
So, but getting back to the case, it seemed that the conservative justices, maybe not Barrett, I don't know, but some of the most conservative ones were willing to grant some immunity. And it was based on this idea that you just touched on, official versus unofficial acts. And unofficial acts would be, I guess, what he did as a candidate, and official acts, what he did as a president. And then I guess there would have to be, if they rule on that, there would have to be all sorts of back and forths over what is official and what is unofficial, which could then delay the start of a trial, correct? And then didn't Barrett offer Smith an out and said, look, amend your indictment and only include the unofficial acts, and then you could go to trial more quickly?
Right, that's correct. And Smith could certainly do that and take up Justice Barrett's suggestion once the Supreme Court rules. He very well could have tried to do that at oral argument and say yes, but the problem is Jack Smith and Michael Dreeben, who's the lawyer under Jack Smith, they themselves don't have probably the power to do that because they're operating a special counsel. And I know a lot about this because I wrote those special counsel regulations in my first tour. They don't give Jack Smith the power, I think, to trim the indictment by himself. He's got to get permission from the Attorney General. So he could go out and get that permission and then try and have a stripped down indictment. Or he could do what I'm saying, which is say, okay, we're probably not going to have a jury trial before the election, but we're going to have a full-blown evidentiary hearing about what Trump did and whether it counted as an official act. That's kind of a second best solution that's available to Trump, excuse me, to Jack Smith and to the American people. It is truly second best. It's not the first best, which is a trial, which is what I think, the American people deserve to have here. I mean, it's been almost 4 years since January 6th, and we still haven't gotten to the bottom of this. And Trump is, of course, as scared as anyone about that sunlight being shed on what happened and what he did.
Would this Supreme Court ruling for Trump doom the Georgia case, which is a state case, but is obviously about the same events?
Yeah, so I do think that what happens in this case, which is a federal case at the Supreme Court, will guide what happens in Georgia because it's a constitutional principle. And so they're saying that a president can't be liable for his official acts, that would chill him in the performance of his duties. And that would be just as true for a state prosecution as a federal one. So I don't think that there's probably a difference between the two. Now, the state one was a really strong case. And as I said, one of the virtues of the state one is that Trump doesn't control it. The federal government doesn't control it. And you can't pardon as president for state crimes. You can only pardon for federal crimes. So if Trump is convicted of hush money or of Georgia January 6th, he might not be jailable, as we talked about, for that constitutional principle, but he can't be pardoned for those things. Those are convictions that stick to him. The problem with Georgia is that, unfortunately, it's like become a cross of Days of Our Lives and Law and Order, or something like that. The prosecutor had a relationship with her deputy, and that has led everything to get slowed down. And I don't see that case as going to trial right now before November, which is a real shame because again, that was another mechanism to try and provide transparency and visibility into what Trump did on January 6th. And we're unlikely to get it before November. Now, the upside of this is that even if Trump is president, that trial can go forward. And it might be Trump will have an argument that you can't even try him in a state or indict him while he's a sitting president. And there's some weight to that, but you can certainly try everyone else. And there's a lot of other defendants there, Giuliani and others. And the entire story could be told through and transparency shed, the light of transparency shed on what Trump did through that trial. Trump can't stop that trial as a whole. He might be able to stop it with respect to himself, but not others.
But the Court of Appeals in Georgia will hear Trump's appeal on whether or not Fani Willis can stay on the case. So if that court says she's got to go, that she's compromised, does that mean the whole case is compromised?
No, I don't think so. I mean, that some other prosecutor comes in. I expect it to be unlikely. I mean, it's obviously um, something that makes good salacious headlines, but really hard to show. The theory of Trump being biased by what happens, I think is really tough. If anything, Trump gained enormously by this whole storyline. So I don't expect that the judge that the Court of Appeals is gonna, disqualify Ms. Willis for this.
Okay, so we've gone through 3 cases so far. They're in various stages and
Wait a couple hours, there'll be a 5th case soon.
yeah. Well, there's also Arizona, but Trump's not involved in that one. Let's get to the documents case. So Trump is charged with mishandling and illegally holding on to classified material after leaving the White House and obstructing the government's repeated efforts to get that material back. And maybe some of that material had very important military and national secrets that should not have been out in public view, certainly not in bathrooms or on stages at Mar-a-Lago. So the
We're
documents
now
case,
bedrooms, because there's a news story yesterday that Trump had very highly classified national security documents in his bedroom months after the Mar-a-Lago FBI raid.
wow, so some spicy bedtime material, I guess. Anyway, that case, I guess, was originally supposed to begin this week in Florida, but the judge scrapped her own date and has not set any date. So she says a lot of issues need to be worked out. What kinds of issues is she talking about?
I have no idea. I mean, this is one we're dealing with it 4th, but this is like such an open and shut case. It's ridiculous. My first job at the Justice Department was National Security Advisor. And you learn this material, it's almost sacred. I mean, it's like the way it's obtained is human sources putting themselves on the line, truly their lives on the line. It's technical electronic capabilities that the United States has. I mean, some of the most important stuff our government does.
Mhm.
And the idea that you could just like leave it around is it's so un-American. It's so frankly stupid that it's, to me, just like so disqualifying. We prosecuted cases like this all the time, and if someone did it negligently, first time offender, whatever.
Well, Biden did it, right?
Yeah, so I mean, in very different circumstances, but like, yes, if it's negligent or something like that, you allow people a pass. If you do it intentionally, the way Sandy Berger did, the Clinton's national security advisor years later, you are going to look at some sort of punishment for that. But what you have here is not just a person who took and stole the documents. It's a person who, when he was asked to give them back, said he didn't have any, and ordered his lawyers to say that. That's where the case, I think, becomes so clear. There's forgiveness for people who own up to the mistake, and who, as Biden did right away, say, hey, I'm an open book, search everything, take whatever, I'll pay the consequences of my action, versus what Trump did, which is lie about the documents. And indeed, it looks like, according to the allegations in the indictment, he actually ordered Walt Nauta, his valet, to try and hide the security cameras or move them, and things like that, so that law enforcement officers couldn't see them moving the boxes and hiding them further. I mean, that is mob-like behavior. It's not the behavior of someone who has any business being near national security information. So for whatever reason, this judge has basically taken the view that the case will be slow walked. This is the same judge who last year tried to slow walk the warrants in a different way, the search warrants, and the results of the search warrants, leading her to be rebuked twice by the very conservative Court of Appeals. I think it was 3 Trump appointees. That's pretty hard to do if you're a district court judge, but this judge managed to do it. Time will tell But I sure hope one way or the other, we get to the bottom of what happened in that case, because what Trump did here seems seriously criminal, and very dangerous to our national security.
One of the hearings she is going to consider is who can be considered part of the prosecution, because Trump is claiming that members of the deep state colluded with Jack Smith to bring the case. What does that mean?
I have no idea. I mean, I really don't. I
I
mean,
mean, what does it mean that
it's
she
like-
would actually hear that?
I mean, look, I don't mind that she hears any defense that Trump wants to make. I just think it should be done on like a normal timetable, not this incredibly slow timetable. I mean, again, I think this does go to a central question about our democracy. We're about to elect our nation's chief officer. One has been accused of stealing and lying about it, really serious national security information. I think the American public deserve to know what happened there. And this judge so far has been able to stymie that process. And that is tremendously unfortunate.
Okay, let me, our listeners, our viewers, so used to radio, our viewers have a bunch of questions that I should probably get to at this point. Should Smith have sought the recusal for cause of Judge Cannon from this case, given all of the highly unusual and frankly unacceptable in the eyes of many rulings that she's issued?
So when I was at the Justice Department, I was in charge of that question, and you have prosecutors across the country who ask to recuse, file motion to the Court of Appeals to recuse a particular judge. And it's the Justice Department's longstanding position that you almost never do that. I mean, I probably had a bunch of requests, never authorized one. And that's because, the Justice Department is a repeat litigant before all of these courts. They'll have lots of cases before this judge and every other judge. And so you don't accept in, like circumstances in which there's like some, like there's a bribe or something like that, an overt bribe, do seek the recusal. So Smith was, Smith as special counsel has to operate under longstanding Justice Department policies and traditions, of which that is one. And so I know it's frustrating. It's frustrating every single time the Solicitor General says no to one of these recusal motions, but that is what happens, in 99.999% of cases.
Many people are asking, why did the DOJ wait so long after January 6th to file charges? Was Garland too slow to appoint Jack Smith as special counsel?
Yeah, so there's certainly that vein of criticism about Garland and the Justice Department. I would say the Justice Department did in the first year indict, I think, like 700 people for January 6th. And one of the ways that you act as a prosecutor is to start with the small fries and try and flip them to try and get bigger fish and bigger fish and bigger fish. That may have been what happened here. It's a little bit of a black box. In a way that's good. You don't have the prosecutors or Garland leaking and saying, oh, here's what I was trying to do and here's why I took so long. We don't know. And it could be that he did move with a lot of speed given the obstacles. Remember, Trump invoked executive privilege to try and block all the information and access to the documents and behavior of him and his staff. So that went to the Supreme Court. My team at Georgetown litigated that on behalf of the January 6th committee and won in the Supreme Court 8-1, with only Clarence Thomas siding with Donald Trump. But that took like a year. So that slows stuff down. Now, it could be on the other side, like the questioners are suggesting, maybe Garland did act too slow. I just don't know at this point. I will say complex cases sometimes take a long time to bring an indictment. Because, look, if you're indicting the president, it's like if you're going to shoot the king to kill the king, you better kill him. Here, similarly, if you're going to indict the president, you better have your I's dotted and your T's crossed. And so that may be what's going on. Now, that's different than Mar-a-Lago, where Jack Smith and Garland acted really quickly from the time they knew that Trump was lying about these documents. They indicted really fast and they wanted a trial quickly. And here you've got the flip side. You've got, Trump's trying to slow it down, slow it down, slow it down to the point where now it looks like it won't happen before November. And just to give you like a comparison, like Sam Bankman-Fried was indicted last year, tried and convicted this year. It took 11 months from indictment to trial, conviction, and sentencing. And other big complex cases work on that timetable. I don't understand why Mar-a-Lago gets some different timetable of years.
All right. So many detailed questions. Let me see. Here's one. Okay, this is kind of a larger philosophical question, given the fact that, well, a lot of people are wondering about the impartiality of the justices these days. Do you think the court should be expanded beyond its current size? If so, what would it take to make that happen?
Sure, I think it would be great to expand the court, to larger than 9, but it's requires, it's a statute. So we started with 5 justices at the founding. We had 6 for a while. For a while we had 10. But since I think 1868, it's been fixed at 9. So in order to change that, you need to repeal that statute or modify that statute to go up in size. Like, let's say it goes up to 13. And I would say 2 things. One is, descriptively, it's impossible to think that statute's ever going to pass, because that would require a majority in the House, which is right now led by Speaker Johnson, who I don't think is wanting to expand the court, and 60 votes right now in the Senate, which is, we're nowhere close to that. And then there's a philosophical point, which is just the precedent that's set. So suppose the Democrats do get the votes to expand the court, say to 13 in 2025. And then in 2029, the Republicans win and they expand to 17. And then in 2029, the Democrats win and go to 27, and then the Republicans win the next election, they go to like 49, and eventually you have like the Supreme Court of India or Switzerland, both of which has like 100 members, and you lose what's special about the court. So there is, I think, a worry on the other side once you start messing with the size of the court.
I would say, in general, how do you think this is playing with the public? First of all, it's, it's confusing, and I follow it for a living, but to go over the 90 plus counts and each case, and if it's a state or a federal, where it is, does the Supreme Court haps and, is weighing in on one case and not another case, and this is federal and this is local, and there's just a lot to keep track of. And it just seems like a lot of noise, and people are trying to live their lives and make ends meet. Like, how is this actually playing, do you think, beyond the
Right.
people here, you and me?
Such a good question.
like
I love this question. I've not had it before, but I would say 2 things. One is, it demonstrates Trump's almost mastery of being such a serial criminal and serial liar that it's hard to keep track of it all. And it just kind of like, it's because there's so many crimes and so many lies, you kind of can't keep them all straight. And so you just kind of throw up your hands and think about, the latest Taylor Swift song or whatever, instead of trying to actually understand this. And that's such a natural human behavior. And it's one that has worked really well for Trump, because if it were just one of these, it might just be easier for everyone to get their minds around. That's number one. The second thing is, I worry about this, that the legal debate about Trump has obscured the policy debate about Trump. Leave aside whether he's a criminal or not. I mean, when you think about someone who wants to blow up our relationships around the world, pull out it, basically not defend Ukraine, give massive tax breaks to the wealthy and oil companies, take away reproductive justice and have and take away a woman's right to choose. There's 50 issues, and we're not talking about those issues. We're talking about, is this jury going to convict Trump? So I'm going to, I think, launch a podcast this summer basically devoted to the policy issues and not the law, and just understand where the two candidates are on these really important questions facing the country. Because, like, look, I'm a lawyer and I'm a Supreme Court lawyer, and I care and I teach constitutional law, and I care vehemently about these things. But I also care about the fact that we have a really important choice apart from these legal debates, and we're not focusing on that. And that's
Okay, so
that's
let me
very-
ask you a question that's nothing to do with the cases then, but does have something to do with what would happen if Trump wins re-election, and that's revolving around immigration. You argued a case before the Supreme Court against Trump's Muslim ban, and the justices did not vote in your way. If I guess 5-4, they did not choose your side in this and allowed that to go through. So, we've heard plans that Trump wants to deport as many as 20 million people. He wants to have a mass deportation centers set up and all this. Whether or not he can do that, I don't know. But given where the court is on this and its prior rulings, how big a how hard would it be for him to do that from a legal perspective? Or are there enough legal roadblocks to prevent what he wants to do, which is round up millions of people and deport them?
Yeah, I mean, I would say a couple of things. One is we are benefit from the fact he's so incompetent that I think he couldn't pull off the deportation of 20 million people. He would pull off the deportation of some, and the announced policy, which would do such damage to our standing in the world and what our nation stands for. So I think the harm would be immense and in some ways irreparable, but I don't think it's 20 million. I think it'll look more like child separation, which was so horrible and ugly and un-American and evil and wrong and frankly criminal. But he couldn't pull that off on a massive scale like he wanted to, and Stephen Miller, his advisor, wanted to, because they're hampered by the fact that people who are competent generally just stay as far away from Trump as you can imagine. With respect to the courts, you raised a really good point. And, like I did argue the Muslim ban case. I argued it the first round of Muslim ban right after that ruling, after the first Muslim ban came in that first week in the Trump administration, and we won that. And Trump then freaked out and said, "See you in court, the so-called judge," and so on. But he got scared and didn't appeal and dropped his appeal, and then issued Muslim ban 2, which was a little bit better. Not much, like it had the country of Chad, which I think Trump thought was some guy. But it was a little bit better. We got that struck down. And then he said, "I'm taking that to the Supreme Court," but he didn't. And then he modified it and had a somewhat more humane Muslim ban 3. And that was the one that the Supreme Court upheld 5-4. I think that to be one of the worst decisions the Supreme Court's made in our lifetimes, probably in the history of the court. I don't think it'll stand the test of time long term. I think it will be repudiated alongside cases like Korematsu and the like. It's so fundamentally a betrayal of what America stands for. But I think your question is right, which is to say, if Trump wins, the Supreme Court's going to let him do a lot of bad stuff, a lot of stuff that's deeply un-American and not who we are. And that's another reason why I don't think we can just rely on the courts to save us. At this point, we are a democracy. That's the genius of our founders. And as a democracy, we as citizens have to understand the issues and what the stakes are, not just about whether Trump commits crimes, but whether Trump's policies are problematic or good, and we should have that debate.
And we'll have that debate on your podcast for one, right? This summer, it's launching. Does it have a name?
Doesn't yet. I'll take suggestions.
Okay. And in the meantime, we didn't get to this, but I urge people to go to the New Yorker and read your debut essay there on cameras in the courtroom. It's interesting.
Thank you.
And thank you for being here. I appreciate that.
Thank you so much. It's a privilege.
It was great to hear your analysis. And thank you for being here as well. And join us again next week. As Janice mentioned, we'll have political analyst Jacob Heilbrunn with us in conversation with Warren Olney on the topic, the right century-long romance with foreign dictators. Neal, thanks again for being with us, and thank you for joining us, and we'll see you next time.